Hoy había una audiencia muy importante en Nueva Orleans, Louisiana, el 5 circuito. Lo que voy a hacer hoy es revisar este caso. Como siempre, ponga sus preguntas sobre cualquier tema de migración, penal, accidentes, aquí abajo. Yo lo puedo intentar contestar. Voy a empezar en inglés, después voy a ir en español. All right, folks. Here's what we got going on today. Going to give a little review of the oral arguments that took place, the Fifth Circuit Court of Appeal. It's also a really good video. If you want to go to Instagram, we did with Aliento this morning. Reina Montoya was at the actual hearing, listened to the judges, listened to the arguments, and we did a video there on Aliento's Instagram page. This is going out to all my friends on YouTube. Saludos, Estela, and on Facebook. So anybody YouTube, Facebook, feel free to drop your comments, questions, concerns down below. Hope everything is good in Colorado. So la audiencia hoy, today's audience, was an oral argument based off of the 2018 lawsuit filed by the state of Texas. Now, do you guys remember the state of Texas, racist, horrible, mean, filed a lawsuit to stop DACA 6 years after the program had already been in existence? It took them that long to say, hey, let's file a lawsuit. This might be against the law of this program. It went in front of Judge Hannon, the same judge that shot down the DAPA program. Everybody and their mother was certain that Judge Hannon was going to do the same to DACA. But because it was filed so late, 6 years after the start, Judge Hannon went ahead and said, you guys waited too long. There's this reliance interest now. I'm not going to end the program, but I will order that no new applications can be adjudicated. You can continue to renew. You can do advanced parole. That's the decision from a year ago, from July of last year. Today's decision was the appeal of that decision, okay? So that's what the oral argument was today. So aquí tenemos preguntas. Abogado cree que el 5 circuito puede tomar DACA incluso después de la nueva regla del presidente Biden. Muy buena pregunta. Excelente pregunta, okay? So aquí es donde estamos. El caso hoy del 5 circuito era basado en el primer demanda de 2018. El anuncio que va a ser el mes que viene de Biden va a ser un cambio completamente a ese tipo de demanda. Lo que debe pasar cuando el presidente Biden anuncia algo, noticias nuevas en agosto, sus razones por el programa de DACA, debe regresar este caso para atrás al juez otra vez, porque es nuevo anuncio del gobierno. No vimos eso con el caso de MPP, de quedar en México. Aunque ellos dijeron un nuevo argumento, igual que está haciendo por DACA, siguió al Corte Suprema, el Corte de Apelación lo negó mandar el caso para atrás al juez de Texas. Pero en mi opinión, dando una opinión diferente, porque eso es uno de los problemas que dijo Texas. Texas dijo, nunca Obama puso esas reglas, nunca publicó esas reglas, por eso es en contra de la ley. So ya Biden haciéndolo bien, debe resultar, en mi opinión, de esa decisión, regresando otra vez con el juez Hannon, para determinar si hay suficientes razones y si hicieron bien el anuncio esta vez. So, muy bien pregunta. Voy a regresar en inglés, terminar en inglés y después en español, pero como siempre ponen sus preguntas en el idioma que ustedes quieren. Okay? So today's hearing is in New Orleans. An oral argument is an awesome thing. I love doing oral arguments. I've done 3 or 4 in front of the Ninth Circuit, random places. Did one in Las Vegas, San Francisco, a couple, and argued oral arguments from the Arizona Supreme Court. They're just invigorating. It's an opportunity to get deep into legal issues, get in front of 3 judges who should know your cases and read your briefs and have that intellectual battle. So today, each side was given 20 minutes. Our side had 20 minutes that was divvied up between the U.S. Department of Justice, MALDEF, the Great Mexican American Legal Defense Education Fund, and the state of New Jersey. Shout out to New Jersey. Maybe I should do my next vacation there for them intervening in this case. Thank you, New Jersey. So they had the arguments, and then Texas had their argument as well, each for 20 minutes, went by super fast. Whenever you're doing an oral argument, you focus on your best argument first because you don't know if you're going to have a time to get to your second or third argument. The idea is you can speak, but the judges at any moment can interrupt you and completely ask you a different question on whatever is in the briefs, whatever is in the record at all, right? So you always lead with your best argument. The best arguments led by MALDEF, the US government, were the standing issue. So in order for you to file a lawsuit in federal court or in any court, you have to have standing. What does that mean? You can stand up? No. Standing means you received a personal injury. You were somehow damaged. You were aggrieved by Amber Heard saying something bad about you. You therefore lost your job with the Pirates of the Caribbean. You punched me in the face. I broke my nose. Therefore, I have standing to bring a lawsuit. So the question is here, Texas, you're a state. What the heck standing do you have to sue to stop the DACA program? Right? So in the original DAPA, they used the argument that they had to give driver's license to people. Wow, what an inconvenience. You have to pay for your driver's license. But nonetheless, that was the argument that got them standing in DAPA. In DACA, they're taking a different approach. And they were even asked today, state of Texas was, and the attorney was like, I don't know why the trial court didn't just do the license, but what they did do is they focused on health care, and they focused on the fact that there was a survey where X percentage of DACA recipients said they would return to their country of origin if they lost DACA. Basically, Texas is saying that's our standing. There's proof that the DACA program hurts us. A lot of logical leaps in there for me to get to, but that's the arguments that they were making in front of the Fifth Circuit today. MALDEF, to me, had a great argument, a really good legal argument saying there's no standing, and Judge Hannon, in his infinite wisdom of a federal judge, made a legal conclusion that was erroneous, issuing a decision on summary judgment when there was a dispute of facts. Now we're really getting wicked and we're getting into legal terminology here. You file a lawsuit, the lawsuit gets filed, it's on the court of record. If you want a quick movement on that, fast, judge, give me something, you file what's called a preliminary injunction. That means rapid, right away, judge, give me a decision. This program has to stop. It's so horrible, it's so unconstitutional, it's so bad, stop it now, stop it now. That's the MPP case that we saw at the Supreme Court last week. That was on a preliminary injunction. Texas tried for a preliminary injunction here in the DACA case. They were shot down because they waited 6 years. Initially, back in 2018, Judge Hannon said, you waited too long. How can you want a preliminary injunction when you waited 6 years for the program to be in place before filing the lawsuit? So that's not an issue in today's court hearing. What happened in today's court hearing was based on what's called summary judgment. So first it comes preliminary injunction. Later down the road in the course of the case, after the record's been developed a little bit more, comes motions for summary judgment, and often, like in this case, cross motions for summary judgment, where you're telling the judge, hey, judge, this case is so obvious. There's nothing disputed here. This is just about the legal analysis. Issue a decision in my favor. That's what happened in this case. Now, the Nina Perales or MALDEF was saying, because there was disputed facts, and what we're talking about standing, about the healthcare implications, about if someone will leave or not leave, the judge shouldn't have issued summary judgment, should have instead gone forward with the trial, and after the trial determine if there was standing or if there was legal conclusions that could be drawn. So on that legal argument, MALDEF actually has probably their strongest argument, in my opinion, from hearing their arguments today, to get a remand back to the district court judge. Remand is a slap in the face. Remand is saying, pop, pop, district court judge, you got it wrong. We, the Court of Appeals, are telling you to do it over again or do it different. And it's hard to being a federal district court judge. I'm not going to sit here and pretend it's easy. If you're a federal district court judge, you have all types of cases: immigration, civil rights, criminal. You got to know pretty much every area of the law. I think bankruptcy might be their only separate courts they have in the federal court. So you got to know all these areas of the law. You don't have infinite resources. You might have a couple clerks, one or two clerks, but it's really difficult to get the law right every single time. When you think, well, you're a judge, you should know everything. No, it's difficult, right, to have this huge docket with all these different cases. But the Court of Appeals exists for this reason, where it's three judges looking at the case instead of one judge. Each judge usually has two or three law clerks on their team that they can do this legal analysis and make sure if anything legally was done incorrect, that they therefore correct it. So I think if we see a victory from our side, it'll probably be on that technical legal issue of issuing a summary judgment order when there were still disputed facts. To me, that would be like the best outcome for the hearing for our side today. Doesn't necessarily mean it's going to happen. You can never just listen to oral arguments and say, okay, I know what the decision is going to be. There's cases where the oral argument is completely about one issue and it comes to the decision, that's one sentence, and 50 pages of the decision is on something completely different. So we don't know what, in fact, the decision will be. Now, it is not uncommon. Some people ask me today, is it uncommon that we didn't get a ruling today? No. It is the absolute most common thing in the world that we don't get a ruling until a few months have gone by. Again, you have three judges there. They don't go back to the room and say, here's our decision. They go back, they have arguments in between each other, they go drafts back between each other, and finally they issue a written decision. All right. So that's what happened today. Texas's argument: inhumane, horrible, mean, cruel. We are hurt by people having DACA, by people having work permits and living in our state, and we want to sue to stop. Literally, they're saying, like, DACA recipients are a plague on our state, therefore we need the program ended. It's just horrible. Horrible to think that people had to sit through and listen to that garbage today, complete legal mumbo jumbo, when we shouldn't have to be talking about it whatsoever in the first place, because what we really need is a DREAM Act. Things that I was also concerned about in today's hearing: at the end of the government's argument, they talked about the concept called severability. Severability means if one part of the order of the law, whatever the issue is at hand, is legal and another part is ruled unlawful, unconstitutional, that we keep in place the lawful part and we get rid of the unlawful part. Why is that important? The strongest arguments from the DACA case that we saw at the Supreme Court were that the executive, the president, certainly has discretion to decide who they want to remove and who they don't want to remove, their priorities for removal. So saying, hey, these DACA folks, I don't want them removed, that seems to be within the gambit of the president. And I think even this conservative Supreme Court will agree on that. The question of whether or not people will also be able to get work permits from a presidential order, that's a little bit more skeptical. In other words, arguments today, there are statutes that we can point to that could be implied that the president has authority, the Attorney General, the Department of Homeland Security has authority to grant people deferred action work permits, and hopefully that would hold up. But to me, the federal government was almost saying, hey, Judge, if you find that we can't give work permits, at least find that we also can continue to still protect people and not order them removed, which of course is a key component. Yes, it's great to be promised not to be deported, but what really matters with DACA is the work permit, driver's license, Social Security that comes along with that protection. So that's something that I did not like seeing from the government in today's hearing. Texas simply asking to find standing, to uphold the decision of Judge Hannon, and eventually, obviously, wanting to completely end the program. Now, is it doomsday? Is it, oh my goodness, the sky's falling, we're going to get a decision in 2 months that says the program must end and it must end today? Very unlikely. It's very unlikely because the U.S. Supreme Court really took effort to spell out in their DACA decision that there's a huge reliance interest, that those that have applied for the program got their work permits, have their houses, have their jobs, all of that. They cannot simply have the rug swept from under them from one day to the next. So even if we get a negative decision, I still think the Fifth Circuit Court of Appeals will adhere to that precedent set by the U.S. Supreme Court on the reliance interest, and it'll be a very gradual ending of the program if it is ended at all. Nonetheless, absolutely 100% motivation to continue to pressure for the DREAM Act because it was obvious today a complete victory for the DACA program will be nearly impossible in the court of law. I'll repeat that again. A complete victory for the DACA program at the end of the day is going to be very difficult, if not impossible, in a court of law. It's the executive trying to do as much as they can, pushing the envelope as much as they can with this Supreme Court. Are they going to let us get away with that? Don't see it happening. Again, we're talking years down the road, but we're talking about the need for an immigration reform. So, recap: Fifth Circuit oral argument today. Decision will come in the next few months. What could happen? We could see a remand back to Judge Hannon to talk about the standing issue, to talk about the summary judgment issue, perhaps to even hold a trial. Or we could see a full-on decision agreeing with Judge Hannon, which would then give MALDEF, U.S. Department of Justice, and New Jersey an opportunity to appeal that to the U.S. Supreme Court. Likely will be taken up, given their lengthy decision in the last DACA case, to have rulings on the merit, be heard sometime next year, with a decision likely sometime next year as well. So DACA is safe for now, but a huge, huge need for immigration reform ASAP. Okay. Voy a cambiar en español. I'm going to switch to Spanish. Please continue to drop down your questions, comments, concerns over here in the comment section. And again, if you have an Instagram, we did one this morning with Aliento, Reina Montoya, who was in the hearing, was watching the hearing, came out, has her reactions as well. Please go check that out. Ok, Estela de Facebook, gracias porque está viendo. A ver, me dice dónde está viendo, por favor. Mi hija aplicó por primera vez el año pasado, le tomaron las huellas y todo está parado, está yendo a la uni, pero no puede trabajar. Se ve que los apenas aplicaron, les den oportunidad. So, la audiencia hoy sí era basado en la decisión de seguir con las renovaciones, pero no dar las nuevas personas que aplicaron. Eso es este caso. No había una decisión sobre eso. Pero en agosto anunciaron que van a publicar las reglas por el programa de DACA. Y si es posible ahí, en esas reglas, que USAS van a interpretar que todos que ya están en fila le pueden dar los permisos de trabajo y el DACA a los que están en fila. Obvio, yo pienso que Texas y los otros estados racistas van a mover rápido a pedir el corte por un orden parando eso, pero sí es el siguiente batalla. Antes que recibimos decisión en este corte de hoy, probablemente escuchamos algo de este anuncio que va a ser el mes que viene la administración de Biden sobre las reglas de DACA, que puede empujar a una decisión en los casos que estamos esperando, como el caso de su hija. So, por favor, si ya no estás siguiéndonos, toque el timbre ahí para que nos pueda seguir. Yo hago un video inmediato el mismo día que esto salga y explicando qué significa ahí. Okay. ¿Por qué será? Siguen aceptando aplicaciones y dando fechas para tomar las huellas? Lo que por primera vez parece que algo bueno pasa. Y eso es el motivo. El motivo de esa decisión era ilógico que puedan aceptar nuevas aplicaciones, pero no puedan dar nuevos permisos. So, es algo que ojalá al fin de día no perdió su dinero y no perdió su esperanza y lo dan, pero esa es la razón por qué este juez en Texas puso ese orden hace un año pasado. So, ojalá recibimos algo bueno en agosto y también ojalá nos vemos algo bueno de este corte que tuvimos hoy. George says, thank you, Ray. I'm really losing faith in our courts. Absolutely, George. We see the uprising across the country, the loss of faith that we have in our U.S. Supreme Court, the absolute fear that I have as an attorney of what's next and what other fundamental rights that they're going to go at that we thought have been fundamental forever. And this decision, the Fifth Circuit, not anticipating anything good. And when it gets to the U.S. Supreme Court, likely the same. So all the more important to elect great people. I know George is working on some campaigns. Met with him recently about a local one here, and to get out the vote, to get people into office that are going to take care of things as opposed to just the same old status quo. Okay. So, ahí estamos, comunidad. Si tienen sus preguntas, sus comentarios, pongan aquí abajo. Básicamente, hoy había argumentos orales, argumentos entre Maldef, el Departamento de Justicia y Nuevo Jersey en contra de Texas y otros estados racistas. Okay. Eso es lo que hemos visto hoy en el corte. Argumentos muy fuertes para nuestro lado a mandar el caso para atrás al juez en Texas. Argumentos de Texas por una decisión a su favor para que el fin pueda ir al Corte Suprema y una decisión ahí si el programa de DACA es legal o no. ¿Y por qué es legal? Pues uno, el argumento de Texas, si ellos tienen poder de estar en frente del corte, es que no tiene poder. El ejecutivo, el presidente no tiene poder de dar como estatus a una persona. Eso tiene que ser un acto del Congreso, que la Cámara de Representantes y el Senado tienen que votar, pasar la ley, el presidente tiene que firmar para dar permisos de trabajos a un grupo grande de personas. Básicamente es el argumento al fin de día del estado de Texas. El argumento de Biden, de Obama, es diciendo nosotros tenemos el poder, hemos usado muchos presidentes en el pasado este tipo de remedio que incluye también el permiso de trabajo. Posiblemente recibimos una decisión sobre ese tema exactamente los siguientes meses de cinco circuitos, pero también ellos tienen la opción de mandar el caso para atrás para más información o por un juicio en frente del juez original de Texas. Muy, muy importante que ustedes siguen renovando cuando es tiempo de renovar, sigue mandando advance parole y si es elegible, mandar su aplicación de nuevo porque en agosto probablemente recibimos nuevas noticias sobre eso. Okay? Questions, comments, concerns, drop them down right now. Getting ready to jump off. Thanks everybody for tuning in. Again, you're watching on the YouTube, on the tube. Subscribe. You're watching on Facebook. Give me a like, give me a comment, give me a share. Show me some love on this Wednesday, July 6th, 7 p.m. Arizona time. And much respect and appreciation for all those that took the time to fly all the way out there to New Orleans to be present, to give our community a presence there at the courthouse. All right. Y muchísimas gracias, lo agradezco mucho, sinceramente, sus palabras. Gracias. Y otra pregunta de YouTube, ¿hay alguna propuesta migratoria viable en futuro cercano? Completamente, absolutamente no. La posibilidad de una reforma más grande, y no creo que sea negativo, no soy un hombre negativo, siempre pienso en positivo, pero también soy realista. Si vamos a ver algo pronto, va a ser por los jóvenes, va a ser por los dreamers, basado en la gente que tiene DACA ahorita y a lo mejor un poco más alta. Pero para una reforma más grande por toda la comunidad, como estamos acercando mucho a las elecciones, los demócratas tienen mucho miedo, no vamos a ver nada grande, desfortunadamente, por toda nuestra comunidad. No es que no merecemos, no es que no es justo, no es como la ley y el mundo debe ser así. Por cuántos años hemos esperado un cambio, por cuántos años hemos dado tanto a este país, nuestra obra, nuestro corazón, de sudar, de dar todo lo que tenemos para que este país pueda seguir creciendo y siendo un poder de naciones en el mundo. Pero siempre, siempre el gobierno, las personas que están en poder, falta el respeto por nuestra comunidad. Y otro ejemplo que tenemos en los cortes hoy. Los argumentos legales no tienen nada que ver con la humanidad, con los corazones de las personas que están sufriendo ese debate político que ellos siempre pongan. ¿Okay? Beatriz también es otras personas que están en espera. Yo metí la aplicación por la visa y ya atrás años me ha llegado nada. ¿Cuánto más tendré que esperar? Si está hablando por la visa U, si es una visa que están tomando menos tiempo, dicen, ¿verdad? Dijo Biden otra cosa de quejar con los demócratas. Dijeron, voy a hacer un cambio muy grande sobre las visas U. Todos los que están en fila, vamos a hacerlo más rápido para que llegue el permiso de trabajo. Yo sigo viendo mi reloj, sigo viendo el calendario, sigue pasando los días y no hay éxito, no hay esos permisos. ¿Dónde está el presidente Biden? Nos dio la promesa que nos iba a conseguir permisos de trabajo por los que tienen visa U sometidos y todavía andamos esperando. ¿Okay? Esperando y esperando y esperando. Una pregunta aquí de María José. Abogado, yo estoy bajo la visa W13. Mi padrastro se casó con mi mamá, pero nunca terminaron el proceso. ¿Me afectaría este proceso aplicando por DACA? Muy buena pregunta. Si hay cosas que pueden resultar en perdiendo su chance de aplicar o arreglar en el futuro, DACA no es uno de esos. DACA está bien, es una discreción que ellos pueden dar mientras que está esperando otro tipo de remedio, de agregar por otra familia, de la visa U, cualquier otro camino sí puede tomar el mismo tiempo que tiene DACA. Muchos de nuestros clientes que están arreglando a sus esposos o esposas también tienen DACA y no hemos tenido ningún problema ni una vez, ni en Juárez, ni aquí en Phoenix, ni en Los Ángeles, los otros lugares que hemos hecho eso, que una persona que tiene DACA, que ya están arreglando. So, sí, de seguro puede seguir haciendo la aplicación de DACA por la primera vez mientras que espera que la categoría sea vigente. ¿Okay? Claro que sí, mi placer y ojalá ese llegue muy pronto. Ahí estamos, comunidad, que tiene muy excelente semana. Ojalá hay puras cosas positivas que nos vemos aquí adelante en el mundo de migración. Y como siempre, si nos está viendo después, le puede poner sus comentarios, sus preguntas aquí, mandarme mensaje directo, que otra vez estoy atrás y mis mensajes directos, perdón, pero siempre cuando tengo tiempo estoy viendo si hay algo ahí, una pregunta que yo puedo contestar. Y como siempre, mandar texto o márcanos aquí este número 602-910-4040. Muchas gracias, comunidad. Y no se deje, como dice Ociel, ojalá alguien marcando a usted muy pronto. Hablo con unos despachos de abogados muy buenos que va a marcar a usted pronto. Muchísimas gracias, comunidad. Tiene excelente día. Aquí nos vemos pronto.